Take a cherry muffin.
Cherry muffin?
Give me 20 seconds on that one.
20 seconds?
And a pink straw and ice water.
Okay. Should be $3 there. And there you go. And there's this one.
Perfect. Did picture with the background on the mug right here? And the drum set right here.
Picture of it?
Yeah.
So this didn't get your, did you want your receipt printed
Oh.
first?
Oh yeah, yeah.
Page actually, There. Yeah, timed out on there.
Sun milk and overruled. And the drum set? Is that the regular?
Picture over here. I didn't know I had a customer. Oh, you're not.
Oh, duh.
There you go.
I'll pick that up in a minute.
Oh,
Stick it in there.
it's fine for it?
Yeah, yeah.
How does he do that?
We'll hear argument first this morning in Case 2807, Ludor versus Union Pacific Railroad Company. Mr. Frederick.
Thank you, Mr. Chief Justice, and may it please the Court. In 1904, this Court held in Johnson versus Southern Pacific that a motionless dining car was in use when a worker's hand was crushed while he was trying to couple the car with a locomotive. That case construed use under the Safety Appliance Act of 1893. In 1911, Congress incorporated the exact same statutory language in the first version of what became the Locomotive Inspection Act. In Brady, this Court held that a motionless car was still in use when an inspector was injured. In Lilly, this Court held that a locomotive tender was in use under the Inspection Act when an employee slipped while servicing a tender that was stationary. The slipping hazard there violated applicable regulations, and this Court upheld the worker's negligence per se claim. In this case, the Seventh Circuit disregarded those precedents and the statute's plain meaning of use. It held that the UP 5683 locomotive was not in use because it was stationary on a side track and part of a train needing to be assembled before its use in interstate commerce. Under this Court's precedents and the statute's plain meaning, a locomotive is in use when the carrier is employing it for the railroad's purposes. A brief stop in the middle of a journey to change crews and to power off the locomotive does not take the locomotive out of use. The UP 5683 was still available as backup power to provide an electrical and hydraulic connection to the rest of the train, and to provide braking capability when the train resumed its journey. Because this case is in the heartland of a carrier's use of a locomotive, the court need not define the precise contours of when a locomotive is not in use. Brady nonetheless suggests a workable standard. When the locomotive reaches a place dedicated to repair, or the carrier withdraws the locomotive from service by making it inoperable. I welcome the court's questions. If I could just start with the statutory language.
Counsel, you use precedents under the Safety Appliance Act and the Locomotive Inspection Act pretty much interchangeably. But I wonder if that's fair, because the sense of use of a locomotive strikes me as different than the sense of use of typical railroad cars. Locomotives, their primary purpose is to move and move things. Rail cars, not the same way. So I wonder if it's fair to just use those precedents interchangeably.
I think it is fair, and there are a number of reasons why, Mr. Chief Justice. Let me just start with a statute. The Safety Appliance Act defines rail vehicles to include locomotives. So locomotives are encompassed within the protections provided by the Safety Appliance Act. Second, when Congress enacted the Locomotive Inspection Act, it adopted the very same words. And using the imperi materiae canon, the court ordinarily would construe the same words to have the same meaning, particularly when they cover the same subject, which is rail safety for the protection of workers. Doctrinally, the court has used that principle and the application of use in multiple cases. I can point you to Urey, to Lilly, to Tipton, where the court has said that the precedents in the SAA context apply equally to the LIA context.
But you can readily think of situations where the point, of course, of my, I appreciate your answer, but the point of the question is that in the LIA you're dealing particularly with locomotives. And, it seems, suppose I have a car in the driveway, I wouldn't say the car... We'll hear argument next in case 21-248, Berger against North Carolina State Conference of the NAACP. Mr. Thompson.
Mr. Chief Justice, and may it please the court, North Carolina law designates the state as necessary parties, the petitioners as agents of the state, and as necessary parties in all actions challenging state statutes. When such actions are filed in state court, the petitioners are defendants and necessary parties. This lawsuit, however, was filed in federal court. And when the petitioners sought to intervene, they were denied, and a strong presumption was applied against their intervention. This outcome should be reversed for two reasons. First, under Turbovich, we are entitled to intervene. The state respondents have candidly and forthrightly acknowledged that they have a primary objective in receiving clear guidance on what law, if any, will need to be enforced. And because that administrative responsibility and interest may not always dictate precisely the same approach to litigation as our interest in defending the law every step of the way, we are entitled to intervene under Turbovich. Second, this case presents foundational issues of federalism. This court recently in Cameron held there are deep constitutional considerations implicated when a federal court is called to pass upon the constitutionality of a state law. And thus a federal court must account for a state designating multiple officials to defend its sovereign interests. There is no basis in this case for a federal court to second guess a state's decision that it needs a representative exclusively focused on vindicating state law. I welcome the court's questions.
You said there's no basis in this case. Is there a situation where you would think it was appropriate for the federal district court to deny intervention where the state law provided specifically that particular state officers be afforded that right?
Well, Your Honor, we'd have to go through the multi-step factors of number one, Donaldson. We need to make sure it's a significantly protectable interest that was identified. Number two, we need to look at Hollingsworth and make sure there was a correct assignment of that agent and creation of that agency relationship. And then under Turbovich, there would need to be an assessment as to whether there was someone else already in the case that had that identical interest and didn't have another interest that was competing at, tugging at the interest that they were advocating.
Well, we often see in these cases as here sort of a political disagreement between the two purported representatives of the state. And is there a situation where that is the claim for the necessity for intervention? You see a situation where that would be second guessed by the federal court?
Well, I can see, Your Honor, where that could be relevant. Here, we don't need to point to Governor Cooper.
We will hear argument first this morning in original case 143, Mississippi against Tennessee. Mr. Coughlin.
Mr. Chief Justice, and may it please the Court. The Court should reject the Special Master's conclusion that equitable apportionment is Mississippi's sole remedy, because it's a remedy that redresses the wrong injury. Mississippi does not claim that defendants are taking more than their fair share of groundwater. Rather, Mississippi's case turns on a different question. Do defendants have the right to control groundwater while it is located within Mississippi's sovereign territory? And the Court has answered this question in Tarrant Regional Water District versus Herman. There, and considering an interstate surface river that had already been apportioned, the Court recognized an injury other than that of an upstream state harming a downstream state by taking too much water. Specifically, the Court recognized that one state may not divert water from another state's sovereign territory, absent a waiver of that sovereignty. And here it's undisputed that Tennessee is diverting groundwater from Mississippi without Mississippi's permission. And they do so knowingly. In the 1960s, the U.S. Geological Survey warned them it was happening. But rather than stop, defendants opened new well fields within 3 miles of the border and substantially increased their pumping. As of 2014, when Mississippi filed its complaint, they had suctioned more than 400 billion gallons of groundwater across the border. They've increased the cost of Mississippi's own groundwater pumping. And by their own admission, defendants' pumping is draining an overlying surficial aquifer that record evidence indicates is pulling contaminants down into the aquifer at issue in this case. Now, the Special Master, in reaching its conclusions, asked whether the Middle Claiborne Aquifer was an interstate resource. This was the wrong question to ask, because the answer doesn't matter. Even if the aquifer is an interstate resource, Mississippi still possesses sole and exclusive control over groundwater within its sovereign territory, as recognized in Tarrant and ensured by the Constitution. And defendants cannot force groundwater across the border without violating this sovereignty. I welcome the Court's questions.
We'll hear argument this morning in case 20-1530, West Virginia versus the Environmental Protection Agency and the consolidated cases. Ms. C.
Mr. Chief Justice, and may it please the Court, in Section 111 of the Clean Air Act, Congress directed EPA to partner with the states to regulate on a source-specific level, which means identifying measures particular buildings can take to reduce their own emissions. The D.C. Circuit gave EPA much broader power to reshape the nation's energy sector, or most any other industry for that matter, by choosing which sources should exist at all and setting standards to make it happen. No tools of statutory construction support that result. First, electricity generation is a pervasive and essential aspect of modern life and squarely within the state's traditional zone. Yet EPA can now regulate in ways that cost billions of dollars, affect thousands of businesses, and are designed to address an issue with worldwide effect. This is major policymaking power under any definition. And though respondents argue EPA can resolve these questions unless clearly forbidden, this court's precedents are clear that's backward. Unless Congress clearly authorizes it, Section 111 does not stretch so far, and Congress hasn't done so here. Second, the words Congress did use in the context where it placed them confirm Section 111's traditional scope. Read together, key statutory terms, like the requirement standards before individual sources and focused on their performance, show that Congress did not greenlight this transformative power. And finally, standing is no reason to avoid the merits. We're injured by a judgment that brings back to life a rule that hurts us and that takes off the books a rule that benefits us. Respondents' arguments sound in mootness, and it's their burden to show that EPA's voluntary cessation and a stay are enough to end the case. They're not. We're asking for the classic appellate relief of undoing what the court below did, and this court has full power to give it. And the weighty issues at stake confirm that it should. In contrast to EPA's important but environmentally focused role, Congress and the states are able to weigh all of the competing factors and constituencies in play. The lower court was wrong to short-circuit that process here, and the court should reverse. I welcome the court's questions.
You start your argument with the major questions doctrine. Do you need that to win?
We do not, Your Honor. We think that the text is clear. The court can use any of the tools of statutory construction. It can focus on the particular words and context, but major questions and the federalism clear statement canon are also textual tools of construction, and we think the court can and should use that as well.
So what is the difference between clear statement and major questions?
So there are multiple versions of the clear statement canons, major questions.